Hello, this is a multi-part series, so if you want the playlist of all the parts, click up here. But now, let's continue with the video and we'll pick up exactly where we left off. Okay, so maybe the way officers are trained leaves a lot to be desired. But when officers do go too far, they can still face consequences, right? If they do something objectively unreasonable, they can still be dragged to court and held civilly liable, can't they? If you've gotten this far in my little video essay, you can likely guess that the answer is probably not. And this is because of a magical thing called qualified immunity, which is a term people commonly throw around, but few people actually understand. Qualified immunity was established in the 1967 case Pearson v. Ray to protect government employees from frivolous lawsuits. But exactly what kinds of lawsuits does it protect police from? Well, the 2001 case Saucier v. Katz established a two-pronged test to determine whether a defendant met the standard for qualified immunity. Number one, did their actions violate the plaintiff's constitutional rights? And two, were those rights clearly established at the time of the incident? Now, you might be asking what the phrase clearly established means in this context, which is very important. Well, clearly established means that there has to be existing case law that declares those specific actions unconstitutional. There needs to have been a virtually identical case in which the officer lost. If a court hasn't already declared that exact action unconstitutional, then the officer is immune from litigation. All the court can do is say, the officer clearly violated the Constitution, but he did it differently than anyone else has done it before, so he has immunity and you can't sue him. But then if anyone else violates someone's rights in the same way in the future, then that officer could be held liable. As long as an officer can come up with new and creative ways to violate people's rights, then they are immune from lawsuits over it. To further illustrate this, look at the case of McCoy v. Alamu. Alamu? I don't know. In which a prison guard pepper sprayed an inmate that hadn't done anything wrong simply because he was in a cell near someone that had thrown liquid on a guard. The courts decided that while pepper spraying someone for no particular reason was definitely unconstitutional and obviously violated the inmate's rights, the inmate still couldn't sue. You see, previous cases had only covered beating and tasing inmates for no particular reason, so pepper spray still got a free pass. An officer can commit an action that everyone agrees violates the Constitution and still be immune from lawsuits. But it actually gets worse than that, because the 2009 Supreme Court decision, Pearson v. Callahan, ruled that courts could actually skip determining whether the action violated the Constitution and instead only decide on whether the law is clearly established. So the courts could have a case with a new, innovative way to be awful and grant the officer qualified immunity because there's no clearly established law, and they can do this without making a judgment on whether the officer's actions violate the Constitution. Courts can now say, this law hasn't been clearly established yet, and then refuse to clearly establish it, meaning that any officer who does that exact thing in the future will automatically get qualified immunity because there is precedent granting them immunity in that situation, but no precedent on whether that action violates constitutional rights. This is understandably confusing, so let's look at another real-life example. The Sixth Circuit's Baxter v. Bracey very famously decided that an officer could not be sued for sicking his dog on a suspect sitting on the ground with his hands up, not resisting. The officer was granted immunity because other decisions only covered sicking a dog on a suspect laying on their stomach, not resisting. According to the courts, these cases are sufficiently different so as to not constitute a clearly established law. But the court also did not make a judgment on whether sicking a dog on someone sitting on the ground with their hands up constitutes a violation of their rights, meaning that any officer under the Sixth Circuit's jurisdiction who does so is going to be granted qualified immunity. By refusing to rule on the case's constitutionality, the court has made the action legal by default. And for the more legally versed among you, the Sixth Circuit also played a neat trick where it issued a summary judgment for immunity but refused to address the larger constitutional question because it lacked adversarial briefing as a result of its summary judgment. The court declined to decide whether the action was unconstitutional because no one had ruled on whether the action was constitutional. This court issues judgments like your girlfriend chooses where to go out to dinner. I don't know, why don't you decide? Even cut and dry issues like stealing someone's private property are somehow covered by qualified immunity. In Jessup v. City of Fresno, officers outright stole $225,000 that was supposed to be taken as evidence through a search warrant. However, the officers couldn't be sued because, you guessed it, no court had ever specified that the theft of items covered by a search warrant violated the Fourth Amendment. Now, this raises the question, if an amendment prohibiting unreasonable seizures doesn't cover literal theft, then what does it do? Being a cop is already the hardest and most thankless job on the planet. And you want to make that job even harder by taking away their legal protections? If a cop hesitates in a life or death situation because they're worried about losing the shirt off their back, that blood will be on your hands. How are cops supposed to do their jobs if they could be financially ruined for sneezing wrong? If qualified immunity goes away, cops will simply have to go through life the same way everyone else does. I can be sued by anyone for any reason at any time. And having to make split-second decisions with a limited amount of facts that could result in you getting sued is just how any violent encounter works for anyone not carrying a badge. But as long as I didn't do anything objectively wrong, I'm probably going to win those lawsuits and might even get them dismissed. Force, and especially lethal force, should only be used sparingly when you need it. If you have to use lethal force, you should have way bigger concerns than whether you might be frivolously sued. If your biggest concern at that moment is future court costs, then you are not in fear for your life. I'm gonna kill you and your whole family right now. Stay back or I'll shoot! Wait, can I shoot? Hold on, let me call my lawyer. Okay, but are you sure I'm going to win any potential lawsuits? Because that's my main priority right now. If untrained civilians are able to pull the trigger without qualified immunity, I'm sure a trained law enforcement officer can figure it out. And remember that not having qualified immunity doesn't mean officers are going to be held liable for every tiny mistake. Qualified immunity is used to stop cases from ever going to trial or being heard by a jury. If qualified immunity is discarded, officers will still be able to defend themselves in court and win their cases, just like everyone else. Also, remember that even if proven liable, officers are less likely to be bankrupted by court costs than you or I, because the taxpayer virtually always foots the bill. The vast majority of officers have indemnification clauses in their contracts, meaning that the department or county often covers the cost of any misconduct lawsuit. A 2013 study found that 99.98% of the money paid as a result of law enforcement violating civil rights came out of taxpayer funds. Even when an officer is forced to go to court over misconduct, they only pay 0.02% of the cost on average. It was also found that out of 9,225 civil rights cases that were resolved with payments to the plaintiff, officers contributed any money at all only 0.41% of the time. And the total cost paid by all officers combined was $170,000. Compare that to over $735 million covered by taxpayers. Officers were provided with free defense counsel and even avoided paying punitive damages. For those of you that don't know, punitive damages are awarded when a defendant's actions are so egregiously negligent or malicious that the court charges them extra money just to punish them. However, of the almost $4 million in total punitive damages awarded by courts in 20 different cases, only a single officer was personally liable for any punitive damages. It was $300, and he never even paid it. In many departments, an officer is more likely to be struck by lightning than ever have to pay a single penny to a plaintiff. The idea that officers are going to be sued out of house and home is simply not how the system works. Indemnification already insulates officers from the financial consequences of their actions. The only thing qualified immunity accomplishes is it prevents victims of officer misconduct from accessing the compensation that they often deserve. And remember that not having qualified immunity doesn't mean that police would automatically lose lawsuits, because that officer would still be protected by the objectively reasonable standard that we talked about earlier. Eliminating qualified immunity just means that a jury would get to decide whether the officer is liable instead of a judge automatically throwing the case out just because no officer had ever thought of beating a suspect with nunchucks before. Qualified immunity doesn't stop officers from being bankrupted by frivolous lawsuits. It protects them from all sorts of lawsuits that couldn't have bankrupted them either way. Even if the standards of qualified immunity, clearly established and objectively reasonable, can't protect an officer, indemnification still can. Even if officers did have to pay a noticeable amount of money, having to think about whether your actions could spark a lawsuit is how it's supposed to work. If a plumber floods your house, you can sue them. If a doctor cuts off the wrong leg, you can sue them. Most people that create pain and suffering by doing their jobs incorrectly can be sued. That's the point of lawsuits. In any facet of your life, if you can't explain your actions to a jury, maybe you should pick different actions. And if you think that allowing a jury to examine your actions prevents you from doing your job, despite the government paying all your costs, then maybe you're doing your job wrong. Listen, kid, why do you think criminals need to get a payout every time they get an ouchie because of our boys in blue? Officers already get fired, and now you're trying to ruin an officer's life over one mistake made in a life-or-death scenario. If you fire and sue anyone who makes a mistake, who's going to do the job? I'm not going to stand here and pretend officers never get fired for violating people's rights. But do they get fired as often as they should? How bad can a police officer be while still being allowed to remain an officer? In a 2015 case, Michael and Michelle Pierce purchased a vehicle at auction that turned out to be stolen. They promptly contacted the Clayton County Police Department and surrendered the vehicle to the police. Soon afterwards, Detective Randy Brashears allegedly improperly removed the vehicle from the stolen list and mistakenly returned it to the Pierces, assuring them that they were now the legal owners. A while later, Brashears corrected his mistake and demanded that the couple return the vehicle to the police department. The couple promptly did so, and then requested compensation for the tax, tag, title bond, insurance, and improvements they had made to the vehicle because of the department's mistake in telling them that they now owned it. Instead of reimbursing them, Brashears arrested the couple on charges of theft and forgery.
Days later, Detective Brashears went back to the Pierce's shop with more officers.
They came in here and snatched me up as if I'd shot and killed somebody.
The problem is everyone, including the district attorney and Detective Brashears, had no reason to believe that the Pierces had done anything wrong. In fact, they had complied with the law and the department every step of the way.
The DA then dismissed the case against Michael and Michelle, saying there is no evidence beyond a reasonable doubt that the defendant sought to defraud anyone.
The Pierces sued Brashears for falsely arresting them and managed to reach a settlement, even overcoming qualified immunity. Despite knowingly making false arrests, Brashears not only kept his job, but was soon promoted to sergeant. And even when an officer is fired, that doesn't mean they can no longer be an officer. A Tampa Bay investigation found 1,776 Florida cases of excessive force since 1985. This includes only cases of excessive force that were investigated and sustained by the department. Of those 1,776 cases, only 158 of them resulted in the officer in question losing their certification. That means that over 91% of sustained excessive force cases resulted in the perpetrator being allowed to continue working as a police officer. Even if their current department does fire them, they can simply apply for a job in the next town over. And that assumes that the excessive force investigation is sustained, and that there's even an investigation at all. When 84-year-old Daniel Daly had his neck broken by being slammed onto concrete by police, Daly was awarded $900,000. However, despite the officer legally being held liable, there wasn't even an internal investigation into the use of force, meaning that an officer breaking an 84-year-old's neck and being found liable in court wasn't even included in the 1,776 statistic I gave earlier. When excessive force happens, departments don't always have to investigate it. If they do investigate it, they don't always have to sustain it. And if they do sustain it, they might not have to do anything about it, with many officers continuing to work at their departments with no real consequences, and many others simply moving to new departments. As another example, take the case of Officer Ben Darby, who I mentioned earlier for shooting and killing a suicidal man. Not only did his department not fire him after the incident, or after criminal charges were brought, but the city also paid for his legal defense and kept him on the payroll for months after he was convicted of murder. The only reason he's not still on the payroll is because he resigned once the news broke that a convicted murderer was still drawing a salary. Now, to be fair, he wasn't fired because, despite literally committing murder, he never actually violated department policy. Although, I don't know how the department justified keeping him on the payroll since he was literally heading to prison. Just a couple years ago, 47 officers at the Alameda County Sheriff's Office were relieved of duties after they achieved a rating of not suited on their psychological evaluations over the course of the previous 6 years. And they were finally relieved of duty. Not fired, of course. They're still employed as deputies and retain all their pay and benefits. They just got put on desk duty until they can get a second opinion on their psych evals. And the only reason that even happened is because one of those 47 deputies got entangled in a love triangle and murdered 2 people. Officers can fail tests, commit crimes, or just straight up murder people and still keep their jobs. And anyone that does get fired can often just get another job in law enforcement. In many departments, an officer losing their certification is so rare as to not even be worth thinking about. And a lot of the firings that do happen are less about the department doing the right thing and more about departments caving to a public outcry. And this is because police departments are given a wide latitude in what policies they write and how these policies are enforced. This creates a system in which officers rarely get investigated, lose their jobs, or lose their certification, even when the evidence definitively points towards misconduct or even criminal guilt. At this point in an incredibly depressing video and series of videos, I think it's important to remind everyone that I'm not arguing that individual officers are immoral. I'm saying that they've been unknowingly inducted into a toxic system. They're people who applied for a job serving and protecting their community and found themselves in a system that encourages violence and removes accountability. Despite this, the vast majority of officers are not particularly violent, and the vast majority of interactions with the public are perfectly cordial. It's difficult to argue that most, or even a significant percentage of police officers are violent bullies. Most officers are genuinely trying to help their community the only way they know how, even in defiance of the system that trained them. For every officer like Ben Darby,
there's an Officer Pegues,
who's one of the officers attempting to de-escalate and later testified against Darby. She sought to save lives and de-escalate conflict, even when the system punished her for it. Unfortunately, cramming departments full of people that want to be heroes means that they're unusually vulnerable to developing the kind of messiah complex that warrior training programs recklessly encourage. Lectures on personal bravery and protecting your flock seem purposely designed to exploit the feelings of people that actually want to do good. These training programs allow bad cops to get through and actively make good cops worse. And the cult-like us versus them mentality that these programs create ensures that departments are predisposed to ignore any criticism over their training by dismissing it as just denial and ignorance of the sheep. But this becomes a much greater problem when we combine it with an extremely permissive legal environment, which nobody actually wanted to create. When explaining the standards that cops are held to, I've already named 10 court cases and 0 legislation. And that's not a coincidence. Legislators don't often sit down and purposely craft legislation that gives law enforcement no accountability. Instead, issues get challenged in court only for judges to discover that legislators neglected to explicitly write accountability into the law, and then those judges' decisions become precedent, and legislators are hesitant to reverse that precedent for fear of being labeled anti-police. Restricting how a new law enforcement agency can act under a new domain or new responsibilities is one thing. Removing permissions that officers were already granted by the courts is a much more difficult political pill to swallow. There's no decades-long conspiracy plotted by bad actors. No court or Congress wanted police trained as killers, and nobody wanted them to operate with this little accountability. It's just something that ended up happening due to human psychology, politics, and coincidence, and has now become politically entrenched and surprisingly difficult to fix. When Graham v. Connor was originally decided, it was actually viewed as a step forward in officer accountability, until institutional norms of policing ended up robbing it of any ability to hold officers accountable. While bad cops and bad politicians certainly exist, they're largely not the reason that we're in this situation. This is about a political and legal landscape that systematically creates bad officers by actively training them to be violent and failing to weed them out through the judicial system. When multiple people make the same mistake, you do not have bad individuals. You don't have bad apples. You have a bad system. And if you find rotten apples at the grocery store, it's not the fault of the apples for being rotten. It's the fault of the grocery store for putting rotten produce on the shelf. This is not a video about how police are evil. I'm not some ACAB nutjob with an axe to grind. I'm also not a bleeding heart idealist that thinks the axe murderer just needs a hug. I'm so pro-law and order that even my biggest gripe with Batman is that he's too soft on crime, and the ghost of Richard Nixon is haunted by me. This isn't a video about how mean and scary the justice system is, or how the poor little criminals deserve love. This is about how our laws and institutions have actively made police worse at their job in a way that erodes public trust and compromises the entire justice system. While most officers want to help their community, good intentions count for very little when you're fed into a machine that systematically breeds psychopathy. And I want you to note that I haven't even attempted to cover all the problems that can lead to police violence or a lack of accountability. The standards video could have easily been twice as long. And there are additional problems such as racial bias, lobbying by police unions, conflicts of interest in internal investigations, and prosecutors unwilling to press charges against people that they often work with. All of these are legitimate issues that can certainly be addressed, but I avoided mentioning any of them because I don't want to talk about what happens when the system fails or when it's corrupted by bias. I want you to understand that even when the system works exactly as intended, it still sucks. If you could wave a magic wand and get rid of all the corruption, bias, and conflicts of interest, the system would still breed bad officers. But if we could wave a magic wand, how would we actually want officers to act?
A question that will be answered next time in part 4? I don't know. It feels like I've made 30 of these things. Anyway, here's a paragraph that I put into the script as a way to vent from how much I had to write that everyone demanded I put in the video, so ta-da.